Good morning. I'm Howard Nations, and thanks for joining this morning. I want to bring you up to date on what's going on in Camp Lejeune. There has been a tremendous amount of work done. Um, 24 was primarily devoted to discovery and to review of tens of thousands of documents. So we got most of the document production out of the way, and we're still in the process of taking depositions, but the government has finished at this point. They finished their discovery, and so when we get through the deposition phase, we're going to come into our next phase, which I'm going to talk to you about now. So the significant things that have happened um, make up about five different topics. So we're going to start with the first one. As of now, there are 2,660 cases on file in the court, and there are 408,000 cases on file, claims on file with the Department of the Navy. Now, you may recall the last time we talked about it, at the end of the period for filing, there were 555,000 claims on file. Now, what has happened since then is that the Department of the Navy has finally gotten through all of those claims to look for duplicates, or what we call dual representation. And duplicates is where a client signs up with more than one lawyer. And so if you have two lawyers and they both filed a claim in your behalf, that's what the Department of the Navy was looking for. And the Department of the Navy found 147,000 duplicates. And it's taken cases where the client hired more than one lawyer. Usually it's two lawyers, but sometimes it's three or four lawyers, all hired by the same client, and each of whom filed a claim. So this whole duplicate representation thing has just caused everything to slow because on those cases, which is 147,000 of them, we can't move your case forward in the system. We can continue to work on the case, but we can't move your case forward in the system until the duplicate aspect of it is resolved. We have to know who the lawyer is. And of course, the lawyers who are not going to end up with those cases are not going to spend a lot of time working on those cases if there's a chance they're not going to end up with them. Now, we're proceeding with our cases, and right now, what we're doing, and this is a major project in our office, we're doing everything we can to identify the dual representations. And why do we have to do that? Because the Department of the Navy, the problem is they identified 147,000, but they don't tell us who they are. So we have no information from the Navy that X number of your cases have duplicate representation, but we're not going to tell you which ones they are. So there's another system coming online, that the Plaintiffs' Executive Committee is working on with the DOJ, and it's called Rubris, and it will eventually identify the representations, but that's months away. We know there's no time when we'll get that. Now let's talk about the new thing that's come up, which are the settlement protocols. This is what the title of this is, and so let's talk about what's happening on settlement. I'll tell you that what has happened is that these new protocols will reduce the time that we have to wait for settlement negotiations by at least a year. This will get us into settlement conferences in mediations at least a year faster than it would have been. So what's happened is that the judge has appointed two settlement masters, whose job it is to create the protocols and the matrices needed for a global settlement. And a global settlement is where you set up a system, a settlement matrix system that you could apply to every case, but then because it's a matrix, you fit your particular case, the facts and particularly the medical facts and so forth of your individual case into a matrix that's set up, and we check all the boxes that you check. And then from that, we understand that the at the end of the day, your number will come out different from another person with your exam, with your same difficulties, because the matrix goes into detail. So it takes into account all of the issues you have. And while the other person may have the same condition or disease, they won't have all the specific issues that you have. So a matrix takes your case, fits it into the system, and checks off all the boxes that you have. And then each one of those boxes has a monetary value on it. And then you add up, when you get all your boxes checked, then you add up at the end of the day what the matrix settlement recommendation is. And that doesn't mean that's what your case is. That doesn't mean your case is going to settle for that. That just means that that's what the global settlement says that your case is worth. And then you have a choice on that. You can settle, and then I come in, and what I do as your attorney is I have to come in and argue the value of each one of those boxes, so that your total amount comes out, and make sure that we cover every single thing that's wrong with you, everything that you have that is compensable, make sure that's all covered by the matrix. And then we argue for increased values in every single box. So that's how we negotiate those cases. But the global settlement sets up the parameters of negotiation and tries to get everybody to on the same page, not in terms of the value of your case, but get everybody on the same page in terms of what exactly do you take into account in evaluating your case, so that the factors that we use to evaluate your case are the same factors that we use to evaluate everybody else's individual case. And those factors come out of what we learned from the trials. So the way it's set up right now, and this is the settlement protocol is changing that, and I'll tell you what the change is, but the idea initially was that we would try a number of bellwether cases. And from those bellwether cases, we would take the data that we get, hopefully, well, what we had about it first is you take the value and all the information given from the jury findings in terms of the value of your case, and in terms of the factors they awarded, the factors they didn't award, and so forth. We put all that data into the matrix. And then we take there'll be an individual matrix for each disease. So if you have kidney cancer, you'll have a disease, or you'll have a matrix just for kidney cancer. If you have a kidney disease, which is different, you'll have a major changes in the matrix to fit kidney disease. And then within kidney disease, which is one of the most difficult to evaluate because there's so many different injuries to ways to injure kidneys to figure out which of those are caused by the toxins is complicated. So there'd be a separate matrix for kidney disease. There'd be a separate matrix just for all the parameters you take into account in bladder cancer. So each one of the diseases will have its own matrix. And if you have that disease, in your case, my job is to develop the individual, make sure that we've got evidence on every single aspect of your case that is compensable. We take all those factors for which you can be awarded money, and we make sure that we have evidence on each and every one of them to fit into the matrix. And that's what we're working on now. That's what we've been working on. And we'll continue to work on because that's a very big deal for us. So the change and what the change has come about for two reasons. Number one, they've been extremely slow. We have, but it's not the lawyers. Trust me, the lawyers are pushing this as fast as we possibly can. But the judges are overwhelmed. You can imagine 555,000 cases with 4 judges. The judges have been overwhelmed. Also, we had issues where we had to go to the appellate court to fight over whether we could have jury trials or not. So the first cases haven't been tried yet. The first Bellweather case hadn't even been reached yet. And so there's no telling when it'll be reached. So this team, these specialists came up with a whole new methodology for evaluating and getting data to go into the matrix. And one reason that there haven't been any bellwethers is the lawyers are not particularly interested in trying the case right now because it would have to be tried to a judge. We were trying to hold off on trials until we can get jury trials because jury trials will be so much more beneficial. And then we can do so many more of them so quickly. So we don't have the bellwether trials from the judges to use to create the data to go into the matrix. Well, that was holding up everything in terms of, because until you get the matrices set up, and that's a huge job, setting up a settlement matrix for 10 different diseases, or whatever we end up with, is a big deal. So what these settlement managers came up with, and this is the brand new part, they say they have a protocol set up for how they're recommending to the court. And the court, there was a hearing on this last week, and the court adopted this plan for moving forward on settlement. The first thing they do is they divide the universe. It says, I'm reading it to you, divide the universe of injuries and conditions that would be part of a resolution. Now, what that means is this. There have been, out of the 555,000 claims that were filed, a lot of them are just absolutely ridiculous. For example, I saw one docket came in of just a handful of maybe 200 cases. 18 of them, the claim was for arthritis. They're claiming that 70-year-old people claim their arthritis was caused by exposure to the toxic water at Camp Lejeune. That's simply not going to happen. I mean, there's no evidence on that. But the other problem is this. So there are as many as 31 different diseases and conditions that have been associated by the lawyers in the filings, claiming that these are caused by exposure to the toxic water at Camp Lejeune. The fact of the matter is that the Department of Justice has recognized 10 of those. And the reason that the standard for recognition is that you have science to support that supports the idea. For example, there's considerable science that supports the idea that kidney cancer is caused by the exposure to the particular toxins that we found in the water at Camp Lejeune. You have PCE over here, you have the diseases it causes over here, you have the clients who have that disease. So there are 10 of those. There are 10 of those that have been recognized, and they were the 10 that were set out in the EO information we gave you earlier when they came out with this, what they call the elective option, which had ridiculous settlement amounts on it. But what we'll post on our website the 10 different diseases and conditions that have been recognized by the DOJ so far. Now, I'm not saying that it's going to be confined to just those 10 for this reason. Before it's over, there are massive studies going on right now. There's studies going on all over the place about this toxic water at Camp Lejeune because this is the biggest lawsuit ever. And so because it is, the scientists went back and took up with where they left off and studies they were doing before. A lot of the injuries, a lot of the diseases that some of you have never been studied. So there are studies going on right now. And it's entirely possible that those studies, before this case is over, that those studies will produce evidence that supports the finding that that disease, an additional disease, is in fact caused by the toxic waters at Camp Lejeune. There was a report came out that caused some of the attorneys who are regular participants in the toxic tort business to believe that there are maybe several more that will be coming out. And so we're going to have to wait and see how the science works out, because the science is being developed right now. And we'll see what science there is by the time we get to the end of the day on this. That's why we never say that your case is not in the top 10, so there's no chance it'll be recovered. Everybody that we've signed up, we think that you either are qualified or there are studies being done that may end up with you being qualified. If it comes out that if it develops that that there's not going to be science to support it, we'll advise everybody that with the diseases that are rejected that they don't have the data, the science, and the expert testimony to qualify. But so the process is you have to come in with an expert witness for your case. We have to bring in an expert witness who testifies that there's scientific evidence that supports the proposition that PCE or whichever of the toxins in the water, that supports the idea that these toxins cause this disease in this client. That's the standard we have to meet in your case. So we have most of our clients are are in the top 10 list. So the next thing that they say after they say that, so they're going to divide the universe. So when they say divide the universe, what they mean is we're going to list all those cases that we think are going to be paid. And then from those, we're going to take out the ones that are not going to be paid. That's when they say we're going to divide the universe of injuries and conditions that would be part of a resolution. And then they're going to move forward only with those cases. They're going to move forward towards settlement only with those cases that they think are going to be compensable. Now, that should be coming out very soon because this report just came out. And this is the first thing on the report. This is their first item. So their division of the compensable from the non-compensable should be coming out soon. And we'll advise you as soon as it comes out. So the second thing, and here's what they're going to do. Instead of trying bellwether cases, they're going to extract a random sample of 2,500 claimants and then that are in the compensable category. And that they will then take those 2,500 claimants, and they have now finalized a questionnaire that will go out to those claimants, and they're going to have those 2,500 eligible claimants fill out the questionnaire, fill out the answers, and then they'll take the data from those 2,500 questionnaires and put that into the matrix instead of trying a bunch of bellwether cases and putting those into the matrix. So that's the first thing. So when that happens, you may or may not be involved in it because there's still 400,000 cases. And so the odds of you being one of the 2,500 are pretty small. But if any one of our clients gets involved in this, we will work closely with you because the answer to those questions on that questionnaire serve exactly the same purpose that that the non-jury trials that we're stuck with at the moment were meant to provide. So in answering those questions, we'll be providing data that goes into the matrix for evaluation of every case. So they're extremely important. So if any one of you does, and we'll receive notice too, but any one of you becomes a part of that group, then that's very important, and we'll work very closely with you to fill out that questionnaire. Now, the second thing they're going to do in order to get the data for the matrix is instead of holding bellwether trials, they're going to hold bellwether mediations. And that's a process to allow the DOJ and say me, any one of you, if you're a bellwether case, to go in and sit down with a mediator and negotiate the case back and forth all day. That's what mediation is until we reach a settlement. And then they'll take the data from those mediations as to how much they settled for and the other data that came out, they'll put that into the matrix. So those mediations are very important. So they're going to use mediation data, negotiation data instead of, now, they will also continue, they say they're going to continue on the track one trials, and that they'll take the data from the track one trials and they'll put those into the matrix also. So then when they get these at least 10 matrices filled out, then the last thing is to negotiate a global settlement, matrix type settlement. So what that means is to create the matrix for each of the compensable diseases that they decide on in the first part of this. Now, what's already been done about this is they've already completed the questionnaire, and the schedule is the Bellweather mediations will begin in the summer of 2025. So they'll begin in a couple of months, and we'll be doing mediations throughout the summer to try to put data into the matrix. And then the next thing is they will begin. They're already working on the matrix for assigning values to claims, and they'll have the idea is, and this may be a little idealistic, but they say that they'll have the matrices completed in the fall of 25. So they're going to do the questionnaires now, the Bellweather mediations in the summer, creation of the matrix in the fall, and then I will have to read this to you. A global settlement and settlement process could be agreed upon and claims administration ready to begin by the end of the year. I read that to you because I want you to know that's not my promise, that's theirs. The idea that they're going to have these cases ready to negotiate settlements by the end of the year is highly idealistic. But that's the status of it. And again, their conclusion, this is the conclusion on their report. The SM's settlement masters continue to seek a resolution of a large number of the present claims within 18 months of the appointment. That is by the end of 2025. So what they're talking about, the last sentence is, and this is important for you, meeting this time frame will require the parties' continued commitment to reaching a resolution, which is absolutely true. So we have to do our part. The settlement masters can't do it without us. So we have to absolutely do our part. So, and our part is this, and here's what we're calling on you to do right now. We ask people in the very beginning to gather, to try to get your own medical records out of the if you had your service at the VA through your veteran portal, go through your veteran, or you can get your medical records from private hospitals and doctors and so forth. And I think most of you probably had your medical since your condition didn't develop until long after you were out of the military. You probably had private care as opposed to VA care. And on your private care, those are your records. Those are your medical records. And you can go to the hospital, you can go to the doctor's office, or you can send them. So it's better to go there and just present it to them. Otherwise, you'll just be added to a long list. But you can go to your doctor and say, I need a copy of my medical records. So it's important that the requests come from you. And you can even tell them that this is extremely important. And of course, your doctors you get to talk to. You can even tell your doctors this is extremely important to you for a recovery on your, whatever your condition is, on your cancer claim or whatever you have. But we need your entire medical record because the first thing we have to do in a medical record is we have to identify in the medical record your diagnosis. We have to know exactly when your diagnosis was made, by whom your diagnosis was made, and what the diagnosis is. Um, Generally, as far as the diagnosis is concerned, we can acquire just a short form uh, medical record, which would be your admit note, your discharge summary, all your lab records, and your operative reports. And if there's any other type of report in there from specialist reports, sometimes there'll be a radiological report or something like that. If we can get the doctor's reports, then we'll meet that aspect of it, which is to prove the diagnosis. However, we need to prove a lot more than diagnosis, because when I said that we have to prove your elements of damage: physical pain, mental anguish, physical disability, physical disfigurement, damage to wage earning capacity, economic losses. All those physical things, our foundation for that is your testimony, you telling us what's wrong, but then we have to back that up with medical records. So we have to get your prescription records, because a major element of your damages will be the prescriptions that you're required, the medications you're required to take. For example, those of you on chemo or radiation, that's huge. Those are huge damages for having to suffer through chemo. And we have to prove up all that. We have to prove exactly how many times you had chemo and over what period of time, and that type of thing. Those are the damages, and those aren't in the admit note and that type of thing. So we need your entire record. The next thing is, I want to tell you about a big topic that's come up now in negotiations. Now they're raising the topic of exposure. Your exposure while you were at Camp Lejeune. What was your exposure to the toxic water, the toxic chemicals? So this has become a big deal, and they're trying to claim that unless you were at a certain place, and they want to know where you live. So, which part did you live in Camp Lejeune? Now, one thing that we've just acquired a housing database, and we'll be able to access it. It'll be set up for our use probably in the next 2 weeks. So we can look, and if you don't recall, if you were in terrorists or where you were on base, we'll have that. But the main thing is not where you were. It'll give us an exact record as to how long you were there, because there's two things on exposure. Of course, you had to be on base for a minimum of 30 days, and they don't have to be contiguous days. They can be just a total of 30 days. But then there's also the issue of how long were you exposed. And so they're trying to make a big deal out of exposure. There are a lot of people that were there that were not exposed, and that during the time frame that you were there, you weren't exposed because you lived somewhere. Let me give you an example. In a discussion we just had, a conference call we just had about this, they raised the issue that if you lived on New River, if you were stationed at New River, you were probably not exposed. Well, New River is a part of Camp Lejeune, but it's a separate part. And they were not on the same water system at New River as they were at Camp Lejeune. But New River is the helicopter base. and the helicopter pilots and everything they're housed there. So they were saying, if you were at New River, you're probably not exposed. That is absolutely wrong, because people at New River, and I had the first case I had come up from New River, but within 5 days after we passed the bill, one of the first people I dealt with was a helicopter pilot. And he said, "Well, I live at New River. Does that count?" And I said, "Well, let's talk about it." Well, what he told me was, I said, "How often did you go to Camp Lejeune?" He said, "Oh, I was at the camp every day." And I said, "What for?" And he said, "Well, we worked out every day. We'd go over there, we'd play racquetball, we'd play basketball, we'd swim, we would do also, I mean, that was our town. Yeah. New River's just where we housed, but that was our town that we went to. We went to the PX, we went to everything there, and we would always end up. And I said, "Well, did you shower there?" "Yeah, we'd shower there. We'd play racquetball, we'd play basketball, and then we'd shower there." And we did that just like almost every day. So this man has a lot of exposure to the water at Camp Lejeune. And the fact that he's lives at New River does not disqualify for him. It's the exposure that you had, and that's the whole idea. They're saying silly things like, "Well, if you lived in Tarawa Terrace, well, during this particular time frame, Tarawa Terrace was not exposed to this chemical." Well, you know, you don't go to your house at Tarawa Terrace um, and stay there for the whole year you're assigned to Camp Lejeune. That's just your residence. There, you are moving all over Camp Lejeune, especially if you're training. And if you're training, you're getting exposure to water every day. You're getting they they have the water buffaloes that bring the water out when you're in the field and can to refill your canteens. And you're drinking so much of that contaminated water every single day. So and you're also um, maybe going swimming in the water. You're going to the gym. You're going to all sorts of things where you're exposed to water. And in when you are in Tarawa Terrace, when there's exposure, uh, you're getting water. You're using water in creating meals, in cooking. You're using water for bathing, showering, everything. So you need to think about, because this exposure has become such a big thing. Each of you who are the injured party needs to think about all of the exposure, all the areas of exposure that you had uh, to the toxic water when you were at Camp Lejeune. Um, I'll give you another example. We had a man that they said, "Well, he's probably not exposed because he he didn't go, he never went in the field. He was assigned to an office. He was he was an office clerk, so he just didn't have the exposure, and so he was a Parkinson's patient. So, and I knew him very well, so we got him in, and I talked to him for a long time, and I asked him, "Tell me, every time you drank water, what?" And he talked about drinking water at the barracks where he was assigned. He talked about at work, there was a water cooler within 6 feet of him, and he drank water there every day. And we go, and he talks about showering, and he talks about using, uh, having water in with his food, and just drinking water. And then we said, and this is why I'm saying this is such an individual thing. And this is what you need to be thinking about. What is your individual story on exposure to the water? So then he said, uh, it, And he said, yeah. I said, did you shower there? He said, yeah, I would shower right there on base, right by the gym, every time I got out of the pool. And I said, well, tell me about the pool. He said, well, when I was just about ready to be discharged, they called me and said, you never qualified. You never passed the swimming test. You never qualified as a swimmer, and you can't complete your discharge until you do that. So they took him off his desk job and sent him over. He had 3 months left and sent him over to take swimming lessons so he could pass his swimming test, and that could go into his 214. And he's finished. He's finished all of his qualifications, and he can be discharged. So when he got over there, they put somebody else in his job, and they didn't have any place to send him back. So they kept him there for the last 3 months of his term as a swimming coach, teaching teaching others to swim. So this guy that they said didn't have enough exposure to the water was in a pool every day for the last 3 months of his enlistment. So that I tell you that story just because to illustrate that all of you have your own story. And so you need to start thinking now, those of you who are the injured parties, you have to start thinking now about the details about everywhere that you were exposed to the toxic water, because the DOJ is trying to make that into a very big deal. So that's the other thing. The last thing I'll talk to you about is the DOJ is making a proposal for DOJ's Department of Justice. They're defending the case. They're making a proposal for this EO elective option for people who may not qualify. So for full compensation, here's where EO may have some actual utility. What they're saying is, and the DOJ, the DON, actually Department of Navy, just came out with a report that said that of cases they're reviewing right now, 6,000 of them are qualified for EO compensation. So what this is if you don't qualify for a regular recovery, say because of exposure, if you don't qualify for a regular recovery, and you have the qualifying injury, but you get knocked out because of exposure, inadequate exposure, you can go ahead and settle. As an alternative, you still have the option to settle your case as an elective option. So if you're disqualified because of exposure from a full claim, you still have the option in certain cases of the elective option, which is based upon the amount of time you were exposed, the disease you have, and so forth. And it runs basically from $100,000 to $500,000. But I just want to mention that to you because that is the one place where you can actually use the elective option as a viable source of recovery. Okay, that's everything I have to bring you up to date.